Reject the wrong applicant the wrong way in California, and you're not just out of tenant, you're facing a fair housing complaint, damages, and the applicant's attorney's fees. I'm Chrissy Wade, broker and owner of Wellspring Property Management. And for over 10 years, we've managed hundreds of units across the state of California. So we know these rules inside and out. By the end of this video, you'll know what you can legally screen for, what you can't touch, and the one habit that keeps you out of court. All right, so let's get into it. Here's the single idea that keeps landlords out of court. Decide your screening rules in advance in writing before you ever see an application, and then apply them exactly the same way to every single person. Almost every fair housing lawsuit comes from doing something different from one applicant that you would for another. So we'll build your process around consistency, and I'll flag the specific California traps along the way. Step 1, write your criteria down and apply them to everyone. Start by putting your screening standards in writing. Your minimum income, your credit threshold, your rental history requirements, all of it. Decide it in advance. Then you apply that identical standard to everyone who applies. The moment you bend the rules for one applicant and not another, you've created the inconsistency that fair housing complaints are built on. And know who the law protects, because California's list is much broader than the federal one. Federally, you've got race, color, religion, sex, national origin, familial status, and disability. California adds on source of income, sexual orientation, gender identity and expression, marital status, ancestry, age, immigration status, primary language, military and veteran status, and more. You cannot screen, advertise, or decide based on any of those. So no adults only, no kids, or no steering families to certain units. Write your criteria down once, apply them to all, and you've removed most of your risk right there. Step 2, income credit and the screening fee by the book. Now, the financial screening, where California has very specific rules. The screening fee first. Under Civil Code 1050.6, there's a cap, and for 2026, it's $65.86 per applicant. You can only charge your actual costs up to that cap, and you have to refund any unused portion you have and give them an itemized receipt if they ask for it. A 2024 law, AB 2493, tightened this even further. You now have to give applicants your written screening criteria before you charge them, and you have to either process applications first come, first approved, or first qualified, or if you pick and choose, you have to refund everyone you didn't select within about 7 days. On top of that, if you run a credit report, you must give the applicant a copy of it within 7 days, even if they don't ask. Now, on income, you can absolutely require that an applicant can afford the rent, but if they have a housing voucher, your income standard has to be based on the portion of rent that they actually pay, not the full rent. And under SB 267, you can't deny a voucher holder over credit history without letting them show alternative proof that they can pay with something like bank statements or pay records. Step 3, criminal history, the biggest landmine of all. This is where landlords get sued the most, so be very careful. You generally can check criminal history, but you cannot use a blanket ban. Posting or applying a no felons or no criminal is illegal in California because it tends to screen out protected groups at higher rates, and the state has gone after landlords for exactly that. There's also criminal information you simply cannot consider. Arrests that didn't lead to a conviction, sealed or expunged or dismissed records, and juvenile records. If you're going to deny someone over a real conviction, you have to do an individualized assessment, meaning you weigh how serious it was, how long ago it happened, and any evidence of rehabilitation, and you need to give them a chance to explain. You can't just see a record and auto reject. And here's the local twist. Some California cities go much further. Oakland and Berkeley and Alameda County effectively ban criminal background checks in tenant screenings altogether under the fair chance housing rules. So in those areas, you don't screen for it at all. Always check your city and county first. Now, step 4, things you must never ask or use. A few hard stops. You cannot ask about or base a decision on immigration or citizenship status. And you can't deny someone just because they don't have a social security number. Verify identity and income with other documents instead. You cannot refuse families with children, that's familiar status, and you cannot reject someone because their income is a voucher or they have public assistance. That's source of income discrimination. And when an applicant with a disability asks for a reasonable accommodation, like an assistance animals in a no pet building, you generally have to grant it, even if you would say no otherwise. These aren't gray areas. They're the exact categories that generate complaints. Step 5, deny the right way. When you do say no, do it correctly, because the denial is where the paper trail matters. Before you ever pull a credit or background report, get the applicant's written consent. Then, if you deny the application or you approve them on tougher terms like a higher deposit, if it's allowed, or a cosigner, and that decision is based on screening report, federal law requires you to send an adverse action notice. That notice tells them the decision was based on reports, names the screening company with its contact information, and tells them they have the right to a free copy of the report and to dispute any errors. Send it every time and send it promptly. It protects the applicant's right, and just as importantly, it documents that you have followed the rules. 2 reminders here before you screen anyone. First, cities and counties stack their own rules on top of the states, especially around criminal history and fees. So check your local ordinances before you build your processes. Second, write it down, apply it evenly, and keep your records. That's an OBS version: consistent written criteria, lawful financial screening, and careful handling of written criminal history is proper denial process. Do those 4 things the same way and every time, and you make yourself very hard to sue. Before you go, here's something most landlords do, and their own screening never add up. The fees, the software, the adverse action paperwork, the legal exposure, and your own hours, it all adds up. So if you'd rather hand this over to a professional property management company, feel free to give me a call, 760-371-4282, extension 101, or reach out at wellspringpm.com. And if you're already a client of ours, we got you handled. See you next time.